Did a judge legally declare the Star Wars sequel trilogy to be bad, setting a shocking precedent which would change the law for years to come? That's what we'll be discussing and more on today's video. Hey guys, this is EckhartsLadder. Hello and welcome to another video. We've got something a little fun today, something I wouldn't ordinarily cover, except for the fact that it intersects two halves of my life quite well. As some of you know, before I started covering Star Wars and doing YouTube full-time, I did practice law. I was only actually a called lawyer for less than a year before I made the switch. But we have a case today where Star Wars appeared in a court case, and that is always exciting. And the short story of this that went around on Twitter and across the internet was that Star Wars was legally declared to be bad, at least the sequels. Now, this was an American court case, and of course, America uses a common law system, so this could be a big deal. The common law system is based on precedent, so when one decision is made, generally that sets the law. At least that's the 5-second explanation. Of course, it's much more complicated than that, but for the purposes of today's video, that's one of the things that was going around a lot on social media. So what actually happened? Is the Star Wars sequel trilogy doomed to a poor legal fate? Let's talk about that. The case comes from the United States Court of Appeal. Now, my legal education was in Canadian law, but I'm going to hazard a guess and say that everything I'll talk about in today's video will still be applicable for the case. The actual details for the case being discussed aren't important or relevant at all. I'll link it down in the description if you want to read it yourself, but I'll jump straight to page 26 for the relevant section. And this part of the decision was written by Justice Lee, and he said, and I quote, "ConAgra thus essentially agreed not to do something over which it lacks the power to do. That is like George Lucas promising no more mediocre and schlocky Star Wars sequels shortly after selling the franchise to Disney. Such a promise would be illusory." Then there was actually a footnote, which is kind of funny, which says, "as evident by Disney's production of The Last Jedi and The Rise of Skywalker." So yeah, we do have a sequel hater judge here, but if you're a prequels fan and you're using this as ammunition against the sequels, take a second and reread the passage, because Justice Lee specifically says no more mediocre and schlocky Star Wars sequels, implying that there already had been bad sequels in the past. So he's probably talking about the prequels, and interestingly enough, he seemed to like Episode 7 because he didn't include that in his footnote. But still, it is true that all of this, including his comments about Star Wars and the footnote, do make its way now into the legal history books. But what does that mean? Well, first of all, judges will often throw a little bit of humor into their decisions, especially if it's a dry case like this appears to be. Judges will often have their own writing style. Some of them are more well known for going off like this. When you go to law school, at least in Canada, you spend a lot of time reading Old English decisions, and that's because of the common law system and the importance of case law, and you end up reading a lot of decisions with some humor in them. Justice Denning, for example, would often write in a pretty interesting style, so his decisions were often fun to read. Now, he retired in, I think, the early 80s, so I don't know if we got any Star Wars comments from him. Either way, though, this isn't really something strange. It's just a judge's way of having fun. But what about the legal implications of such a thing? Because people are saying that the Star Wars sequels being bad is now settled law. Well, there's two things to talk about for that. First of all, the Star Wars sequels being bad is not a question of law, it's a question of fact. Generally, when you talk about legal questions, you have questions of law, questions of fact, and questions of mixed fact and law. A question of law would be, for example, what's the test to determine if someone was negligent? What's the specific legal test that you use? A question of fact is, sort of as it sounds, what's the decision based on the facts of this case? So if a judge was to decide whether a person was home or not, that would be a question of fact. And a question of mixed fact and law is applying facts to a legal test. So if there was a test for a movie being schlocky and mediocre, then you could have a question of mixed fact and law when you're applying the Star Wars sequels to that. But anyway, this isn't a decision of law, and if there actually was to be a case that somehow hinged on the Star Wars sequels being mediocre, then this wouldn't really be very good precedent, because for one, the judge made a determination of fact or mixed fact and law without any actual evidence. I doubt the lawyers in this totally unrelated case presented evidence on the Star Wars sequels. This is essentially just his opinion, and generally questions of fact are answered based on the specifics of the case. Although because a movie is a sort of thing that's happened and is static, I guess you could argue that there is an objective test you could make. That sort of leads into another problem, and that's the intention to create precedents and also the intention to answer an important legal question relevant to the case. Often you'll hear legal scholars or lawyers or law students even to use the terms ratio or obiter. A ratio refers to the main takeaway from a case. So, for example, the takeaway for a case could be that the legal test is X and that you use that moving forward. Obiter, which stands for obiter dictum or obiter dicta, is instead just an expression of opinion and does not carry the same legal weight. And when a judge is deciding another case and there's obiter dicta from a higher level court, they're not required to follow it. Now, when you're talking about a question of law from the Supreme Court, it can still be very persuasive. And with the Canadian Supreme Court especially, often justices will make decisions based on whatever they're talking about, which is usually a legal test that will have vast ramifications for a certain part of law. But then they'll also often say that although we weren't specifically asked to answer this question, I think that the trend is moving this way, or I think the legal test is set to change, etc., etc. That is the type of obiter that's persuasive. The Star Wars sequels being schlocky and mediocre, according to this one judge, is obiter and non-persuasive obiter at that. I do also want to mention judicial notice. Judicial notice is basically the idea that a judge can take a certain fact as truth without having to have it be entered into evidence. Basically, judicial notice is a sort of practical rule. It's so that not every single little piece of evidence has to be entered formally into court. And in my experience, the example you're usually given in law school is like the day of the week. A judge can take judicial notice of the day of the week, even if they're going back and saying, okay, this case took place on the 30th of September in 1980. They can look at a calendar, take judicial notice of the fact that that was a Tuesday, which could be relevant, for example, if one of the contentious issues was whether a person was at a bar on a wing night, which would only be offered on a certain day or night of the week. That's just an example. Something like a subjective or objective even opinion on the quality of art is not something that could be taken through judicial notice. You'd have to have evidence entered if you were going to make a real factual or mixed question decision on whether the Star Wars sequel trilogy was good or not. So no, for a bunch of different reasons, obviously this is not a settled question of law now. I mean, I'm pretty sure that was pretty evident to anyone who even read an article about this story, but I also thought it would be funny to take a closer look from a legal perspective at what actually happened here and why judges just making jokes and giving their opinion in court cases isn't legally binding. But guys, that's all I have for now. I hope you enjoyed this video. Until next time, be safe, have a good one, and may the Force be with you.